question we commonly get is, I own a business in Florida and I'm going through a divorce. What's going to happen to it? What's going to happen to my business? There's a lot of questions that go along with that, but if you have a business in Florida and you're married and you started that company during your marriage, you can presume that it is entirely marital. It's 100% marital property, and therefore it's subject to what's called equitable distribution and will be divided, usually in half. Now, there's a bunch of other considerations that go into it, whether or not they're offsetting other assets that the other spouse will get, the income or revenues the company is generating, how much profit the company is producing, what level of retained earnings remain in the operating account versus necessary operating capital to keep the business going, the personal goodwill, the enterprise goodwill. Those are very important concepts when you're talking about a division of a marital corporate asset or S Corp or LLC. It doesn't have to be a corporation per se. But if you have a business in Florida and you're going through a divorce, that business needs to be valued and it needs to be distributed or divided, and the spouse who's not operating it with you is going to be getting a portion of it. So it's imperative that you have good books, good accounting measures, so you can give that information over to someone who's going to eventually value your business. There are a number of ways to do the valuation, whether it's through a private accountant, a business valuation expert, a business broker. There's an actual offer for purchase from a willing buyer. All kinds of different ways to value a company. But it's important that you keep good records, because if your lawyer doesn't have access to those records, we can't defend you from saying, well, the company isn't worth $20 million. It's worth quite a bit less. Why do we know that? Well, we just know that. No, we have to have records to prove it. It's also very important that you continue to do with the company what you have historically done. We'll get more into that if you were to work with our office. But generally speaking, it's a big red flag to change dramatically the corporate structure, turn away a bunch of new work, shut down avenues of referral sources that you previously had, let go a bunch of staff, change executive level staff. All that sort of stuff is a big no-no. There are additional considerations if you are currently joint operating a business. We see that quite a bit, where you and your spouse are working together in a company. That presents additional difficulties, but generally speaking, it is error for the court to say at the end of the case, at the end of the divorce, both of you go back and keep working in the company. There are a few cases that say that that's just not a realistic outcome or realistic expectation. So you can expect that one of you is going to be keeping that company, keeping it operating, and the other is going to be bought out. This is a big, big issue, and it's important that you get the right representation. And if you have a business lawyer, someone who you've worked with in the past to help you through corporate issues, it's very important that your lawyer for your matrimonial issue knows and is working well with that corporate lawyer, because they can be extraordinarily helpful. Same with your corporate accountant or your tax accountant. So it's a complex issue, but it's something we deal with all the time, very prevalent. The businesses are stressful to operate, they're stressful processes, and they create a lot of tension in a marriage. And sadly, we see that quite a bit, but we're equipped to handle it. And if you need any help with your dispute involving a marital business, make sure you engage Family First Legal Group to help you. If you have a non-marital business, a business that you started before the marriage, and then you got married after it had been up running for a number of years, there's a different analysis. And it depends upon a great number of factors, mostly focused toward what types of commitment, energies, resources went into growing the business during the marital period from yourself and from your spouse. Because there's going to be an argument that you have contributed a bunch of your marital labor and marital energy to improving the value of this company. If you had a valuation of the company done before you got married for the purposes of getting a prenuptial agreement, that's fantastic, because then we can compare and contrast the two between the date of filing your divorce and the date that you came into the marriage and what the value of your company was. If you don't, which most people don't, it's not an absolute loss, you can get business valuations backdated if you have good records. If you do not have good records, it's a little bit shaky. So you have to be prepared that that's going to be a bit of a dispute, and be ready to defend it through knowledgeable, experienced counsel. If you have partners in the company with you, not intimate partners, just a business partner. You have a partner with you in the company. It's important that they're on board and they know what's coming down the pike so they can protect themselves in the event that there's a buyout required or some change in the corporate structure by way of the divorce. So Family First Legal Group, one-stop shop if you need help with your marital, divorce, paternity actions in Southwest Florida, even if you have a marital company or non-marital company. Thanks.